The U.S. versus Texas, Immigration and Presidential Authority. I'm Donna Davis, and this is Scholars Mate. Hello, and welcome to Scholars Mate. I'm your host, Donna Davis. In April, the Supreme Court heard the case of U.S. versus Texas. The case centers around President Obama's 2014 executive order to postpone deportation of some illegal immigrants. 26 states, led by Texas, object to the president's action, saying it exceeds his authority and infringes on the rights of states. Joining us via Skype to discuss the case is John Eastman, the Henry Salvatori Professor of Law and Community Service at Chapman University's Fowler School of Law. He is the founding director of the Claremont Institute's Center for Constitutional Jurisprudence, and he served as a law clerk with Justice Clarence Thomas at the U.S. Supreme Court and with Judge J. Michael Ludig at the United States Court of Appeals for the Fourth Circuit. He earned his J.D. from the University of Chicago Law School, where he graduated with high honors. And also joining us via Skype is Kevin Johnson, who is Dean Maybe Apollos, Professor of Public Interest Law and Professor of Chicano Studies at the University of California, Davis School of Law. A magna cum laude graduate of Harvard Law School, where he served as an editor of the Harvard Law Review. Dean Johnson earned an A.B. in economics from UC Berkeley, graduating Phi Beta Kappa. He clerked for the Honorable Stephen Reinhardt of the U.S. Court of Appeals for the Ninth Circuit and worked as an attorney at the international law firm of Heller, Ehrman, White, and McAuliffe. Gentlemen, thank you both for joining us.
Thank you.
Thank you.
So, Dean Johnson, could you explain why the Obama administration's actions are within the president's authority?
Well, the president's action and the deferred action program that he announced in November 2014 really falls within the power delegated to the president under the Immigration and Nationality Act. The Immigration and Nationality Act is the omnibus immigration law that regulates admission and deportations from the United States. And the Deferred Action Program, and it's known as the Deferred Action for Parents of Americans because it deals with parents of U.S. citizens, undocumented parents of U.S. citizens and lawful permanent residents. It basically is a statement by the Obama administration, a guidance, as the administration puts it, that defers the removal of these parents. And there's a long history of prosecutorial discretion that any law enforcement agency exercises, including the President of the United States. And in the Deferred Action for Parents of Americans program, the administration has decided in this guidance to not focus on the removal of parents of Americans. Now, this history of prosecutorial discretion goes back for generations, really. And basically, the administration in this instance said, what we're trying to do here is focus on true dangers to our society, immigrants who've been convicted of crimes, and immigrants who are suspected of terrorism. And so long as you're otherwise law-abiding, we're not going to focus the removal machinery on you. So this program, in a sense, it's an anti-crime, anti-terrorism program, as well as a program that benefits undocumented parents of Americans. It's a discretionary program. It's very important to remember that it's limited relief. It does not grant any amnesty, does not grant any lawful permanent resident status, does not grant anything permanent in any way. There's no path to lawful permanent residence, no path to citizenship, and a new president could do away with the Deferred Action Program. Basically, this program is limited in duration, limited in scope, and in many ways is very consistent with the long history of prosecutorial discretion exercised by law enforcement agencies. But what I think is very important to remember is this is one step in a much larger national debate about immigration reform. In the end, the only place where immigration reform of any durability is going to take place is be accomplished is through Congress. And I think President Obama has taken a measured step in this instance to fill the gap in the interim before Congress acts. And to me, it seems very much within his powers as president and under the Immigration and Nationality Act.
And Dr. Eastman, how do you respond to Dean Johnson's argument?
Well, I think I disagree on almost every point, but that's what I'm here for, right? So the first thing, Congress has acted. We have a very comprehensive immigration law. The Immigration and Nationalization Act goes back decades. It gets amended periodically. The problem is this president doesn't like what the existing law is, and he's taken it upon himself unilaterally to effectively change it. The one thing I do agree with Dean Johnson is that his actions here can't bind a future president. But I fundamentally disagree with the claim that he has not given a lawful presence to these people. The DACA memo from 2012 and the DAPA memo from 2014 specifically say that anybody that's put into deferred action status, and there are more than 5 million people who qualify, will be deemed by the administration as lawfully present in the United States. And that's language that is used in the memo, and it quite frankly got the Solicitor General of the United States into quite a pickle in oral argument 2 weeks ago before the Supreme Court. Chief Justice Roberts specifically said, how can you say on one page of your brief that they're lawfully present in the United States and the very next page say that they're not lawfully in the United States? And the fact of the matter is these executive orders, not executive orders, just guidance memos by the administration have deemed people lawfully present in the United States who under the law are not lawfully present. And the statutes are quite clear. Any immigration official that comes across somebody who is not lawfully present in the United States, they are supposed to initiate removal proceedings. The statute uses the word shall repeatedly. That means there really is no discretion even on an individual basis. But there's certainly no discretion to do what the president has done here, which is wholesale, categorically change the terms of who's eligible to be lawfully present in the United States. And then there's a third aspect of this. Having deemed them lawfully present just on his own authority, without any recourse to the law itself, he then gives out work authorizations. And there's no credible argument to be made that handing out benefits or work authorizations and Social Security benefits and making people eligible retroactively for 3 years of earned income tax credit funding and tens of billions of dollars in funds out of the U.S. Treasury without any congressional authorization whatsoever. There's no credible argument to be made that that's an exercise of prosecutorial discretion, even if I were to accept the notion that the president can wholesale say, I'm not going to enforce this law against 5 or 6 million people. And we have a provision in Article 2 of the Constitution that was designed to address just this problem. It's called the Take Care Clause. Presidents often think that that's a power given to them, but it's really a duty imposed upon them. They have a duty to take care that the laws be faithfully executed. And the reason that clause exists was we had a king that we had just left, we fought a revolution to declare independence from, who was unilaterally suspending laws and not enforcing them in the colonies. And they didn't want a president that would have that kind of power. And that's why we have the Take Care Clause in the first place. That doesn't mean the president has to enforce the law in every single instance. The Supreme Court has recognized they have discretion. But it does mean that he cannot unilaterally change the terms of the law, even temporarily. And he cannot deem people lawfully present when the law says they are not lawfully present in the United States.
Now, work authorization is given under a regulation that was put into place by one of Dr. Eastman's heroes, Ronald Reagan. This is a regulation that was put into place in the 1980s. It's not a regulation that's currently before the United States Supreme Court. It's not a regulation that's been challenged. It's a red herring to raise that as an issue here. And it's also a red herring to say that language in the memo about lawful presence is an issue here, because as came up in the oral argument in the Supreme Court, that language could be deleted and the program would still be in place and there'd be deferred action. I mean, it's been very common for presidents throughout the years to defer action and not focus removal efforts on particular groups. There's been some famous people who've been subject to deferred action. One of them is John Lennon, who was a member of the Beatles at the time, who was in the United States, and under the immigration laws was subject to removal. The courts, including the U.S. Court of Appeals for the Second Circuit, held that it was appropriate to exercise deferred action and not force John Lennon to be removed from the country. And in this instance, the work authorization issue, if you want to challenge the Reagan-era regulation, challenge the Reagan-era authorization, undocumented immigrants, DACA or DAPA recipients, aren't eligible for almost any public benefits. So I don't know what these benefits are. Work authorization is work. It's not a benefit. And I don't know what anything says in that particular card, how that changes the fact that this is temporary relief. It's revocable if a crime is committed. It's revocable if the law is violated. It's revocable if a different president is in place. And it's important to remember there's incredible amounts of discretion included in the Immigration and Nationality Act. The United States Supreme Court, in fact, in Arizona versus United States, held that the states had limited power to be involved in immigration enforcement, and emphasized one of the reasons you limit the states in their involvement in immigration enforcement is because there's so many discretionary judgments in the hands of the federal government in immigration enforcement. And the Immigration and Nationality Act has been referred to is full of a reservoir of discretion for the executive branch in deciding how to enforce, when to enforce, and where to enforce. And one last thing, and I think it's, that there is a reference in the briefs, I think less than 10 pages total, to the take care provision of the Constitution for requiring the president to enforce the laws. The take care provision has rarely been interpreted by the Supreme Court and has never, ever, 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 never been interpreted to preclude the exercise of prosecutorial discretion. So I think, and actually it seems odd to claim that we should expand this moribund provision of the Constitution and inject it with new life. And in fact, the truth of the matter is I don't even think it came up in oral argument in the Supreme Court, so it's very unlikely to get any traction with the justice, would be my guess.
Professor Eastman, and then also Dean Johnson, could you please, this is a very complicated issue. You've both talked at length on the various positions. Is there any way that you could take it down to, let's say, 5 sentences in terms of what is it that you hope to accomplish, Professor Eastman? How do you see this as a proper outcome? And then Dean Johnson, if you could also take it down to 5 sentences so that we can understand what is it an outcome that you see that would be appropriate. Professor Eastman, if you'd start.
Sure. Our Constitution gives plenary power over immigration and naturalization to Congress, and Congress sets the rules who's allowed to be admitted lawfully to the United States. The president doesn't like what the current set of rules are, and so he unilaterally changed them with his memos from his secretaries of Homeland Security, changing the criteria effectively for who's, and they use the words, lawfully present in the United States. They claim that's an exercise of the traditional prosecutorial discretion that every executive, every line police officer has. But the difference is this. A line police officer, say a highway patrolman who sees you speeding a few miles over the speed limit and exercises his prosecutorial discretion to not pull you over, doesn't give you a license to continue to speed. And it doesn't give you access to access to work authorization is a benefit. The Clinton administration, general counsel for the INS, specifically said even in prosecutorial discretion, we could not give out work authorizations or other benefits. That goes beyond the scope of prosecutorial discretion. So the issue here is, has the president effectively changed the law at least for the remainder of his term, change the rules by which people are lawfully admitted to the United States and legally allowed to work in this country, and with work authorization, legally allowed to get things like driver's license and Social Security benefits and earned income tax credit and other benefits that are triggered by that lawful presence designation. I don't believe the president has that authority under our constitutional system. The lower courts have rejected the president's claim here, although they never reached the constitutional merits. But the Supreme Court itself asked for the constitutional question to be addressed. And I think it's an extremely important question that goes to the heart of the separation of powers we have under our Constitution.
Dean Johnson, do you agree that that's basically the crux of the matter, or do you feel that it really concentrates on a different issue?
No, I think the crux of the matter here is there's a dispute in this country about immigration reform and the proper avenue for immigration reform. Congress has not passed immigration reform. There's no likelihood in this administration that immigration reform will be passed. The president has taken some steps consistent with the Immigration and Nationality Act, I believe, and exercised his discretion to focus the immigration laws on removing criminals and removing suspected terrorists from the United States. He's decided to focus his limited enforcement resources on the dangers to American society. And he's decided not to devote resources to otherwise law-abiding people. And I know there's a claim that they violated the immigration laws, and they have violated the immigration laws, but he's decided to focus on people convicted of non-citizens, undocumented non-citizens convicted of crimes, lawful immigrants convicted of crimes, and suspected terrorists. And that is in the core of the exercise of prosecutorial discretion in what we want our president to do. And different presidents over different times exercise that discretion in different ways. But this really is, in some ways, I view DACA and DAPA as pro-law enforcement, pro-national security, and focusing limited resources on protecting America.
Dean Johnson, do you feel that the president's rights to take the law and change it in the manner that he has, if this were a totally different issue, would you still feel that he were within his rights in the way that he has taken this, the way he has, in the direction that he has?
I think it's inaccurate to say that the president has changed the law. I think the president is enforcing law in the best way he thinks appropriate. And I think he's exercising his prosecutorial discretion in a way consistent with the executive branch and consistent with the Immigration and Nationality Act. I think he understands and has admitted that he's not Congress and can't pass laws, but he can decide how to enforce the laws. And we expect law enforcement all the time to say, for example, we're going to focus on drug dealers, not people who simply possess drugs. We're going to focus on serious tax cheats, not minimal tax cheats. I think that's what we expect our executive to do, to protect our safety, to protect our nation, and exercise judgment in figuring out what the best way of doing that is.
It's not me that says that the president changed the law. When the president 2 years ago was pressed for not doing enough for immigration reform, he said specifically, "Have you not been paying attention? I just changed the law." So maybe he needs to get the memo that he didn't change the law, but he claimed that he did. The second thing is, look. Suppose a President Cruz were to come in and wants comprehensive tax reform. He said we should abolish the IRS and reduce the corporate tax rate from down to 15%. And then he says, just in the exercise of my prosecutorial discretion, we're not going to prosecute for tax violations any corporation that only pays 15% of their taxes rather than the going rate according to the law. People would be screaming from one end of the country to the other about the effective rewriting of the law that is beyond the president's capacity. And that's what we have here. And the notion that if Texas prevails and has standing to challenge this change in the law, this wholesale and categorical suspension of the law that this president has done here, that there are very few instances where we've had anything like this in our nation's history.
All right, let's take some questions from our viewers. We have a question from Marie Thomas. Dr. Eastman, apart from the legal questions, is the policy a good one?
I don't think it is a good one. Look, We tried an amnesty back in 1986. It was a very generous thing. But what we learned is that it created a magnet for an even larger wave of illegal immigration. If we're going to have borders, if we're going to recognize the distinction between citizen and non-citizen, and we're going to recognize that the Congress is the one that has plenary power over immigration and naturalization, then when they set what the rules are, when they determine those rules by law, then it's important that we follow that law and not act like it doesn't exist. Otherwise, we not only have no control of our borders or no control of our immigration system, we have no control of the law more broadly. And so the notion that people will be rewarded for violating the law if they can violate it in massive enough numbers is a very dangerous thing, it seems to me.
Dean Johnson, how do you respond to that?
Well, I think that the policy makes sense. I think that comprehensive immigration reform would make more sense, but I think that some kind of temporary relief that allows the president to focus removal efforts on dangers to society is more sensible than focusing on trying to remove 11 to 12 million people that time and again it's been shown it's not possible to do. So I think focusing those kinds of resources on true dangers to society is a sensible thing to do. It's what we expect our chief law enforcement officers to do. And this kind of decision here, I think, is a sensible one.
We have one more question from Derek Davidson. If the president has the authority to make these changes to immigration law, are there any limits to what changes he can make? I think we did touch upon this, but Dean Johnson, why don't you take a stab at it?
Well, since I don't think there's any changes in the law here, it's hard for me to say what future changes in the law can other presidents do. But I do think that it's important to remember that you can only act as the executive in interpreting a statute. You can't rewrite the statute. I agree with Dr. Eastman there. And I think it's important to realize that, the president enforces the law, Congress passes the law, and so you have to act consistent with the statute. And I think my argument here is the Immigration Nationality Act bestows strong enforcement discretion on the president. He's exercising that discretion in a sensible way. We should defer to that judgment, like we defer to the president's judgment in many other areas under the law.
Professor Eastman?
Yeah, I mean, I disagree. I think in doing this wholesale, the Supreme Court has addressed this issue in a case a number of years ago. It said there's a difference between prosecutorial discretion and suspension of the law. And they reserved in that case the right to decide when the president has crossed the line. And when you're not dealing with things on a case-by-case basis, but effectively writing new criteria for who is eligible to be in the United States, to have a lawful presence in the United States, to be legally entitled to get work authorizations and other things, he has changed the terms of what the law sets out. And I think that goes beyond his prosecutorial discretion. And if he can do it here for 5 or 6 million people, why not for the entire 11 million people? Or as I pointed out earlier, why not in other areas of the law as well? The immigration statutes do not give remotely the kind of discretion that's necessary to sustain this program.
Okay, and now it's time for Answer This, where each guest asks a question directly to the other. Who'd like to go first?
I'll go. John, what kind of immigration reform would you be supportive of?
I think our immigration policy has become too bureaucratic. I would like to see an increase in lawful immigration, and I would like to see the process streamlined. But I would also strengthen the enforcement because if you're going to have laws on who can legally come to the United States and then not enforce them, you encourage a lawlessness, you encourage line jumping, and you make it very difficult for people who actually want to comply with the law to do so. And I would streamline that process, and then I would beef up the enforcement to make sure that whatever rules we set out get enforced and that people know what those rules are and they comply with them. So my question back to Dean Johnson, I think, would be, are there any limits on what the president, either this president or the next president, can do with his executive orders in dealing with immigration when you have the immigration acts on the books?
I think there are distinct limits. I think that, for example, if he gave any kind of path to permanent legalization or lawful permanent residence status or citizenship, that would step beyond his prosecutorial discretion. I think that, and that's important, if you try to do anything more than temporary with respect to undocumented immigrants, I think that'd be a violation of the discretion of the statute. And I think that, any kind of, obviously a creation of some kind of immigration category of lawfully admitting people for categories that don't exist in the immigration statute wouldn't be legal. I think that concocting deportation grounds that don't exist under the statute would violate the statute. I think that acting inconsistent with the statute, and I've actually spent a lot of time briefing cases that claim the administration wasn't accurately interpreting the statute and was trying to wrongfully deport people. I'd be against, because I do agree with you. It's an important area of agreement. I do think we have a difference of opinion about whether the president's complying with the law, but I do think it's important that the president do comply with the law. And I think it's important that the laws are the ones passed by Congress, and you shouldn't be rewriting the law. And just like you said, it's bicameral approval of laws by Congress that make things laws. And I think that's an important limitation on the president. So when the president acts inconsistent with that statutory authority, I think he's crossed the border between law and lawlessness.
All right, and now it's time for We Agree, where each guest names something the other said that he agrees with. Who'd like to start?
I'll go first on this one, because I think that last statement by Dean Johnson is extremely important. Congress makes the laws here, and our disagreement on whether the president is following the law or not is important. I believe the president is not following the law here, but I agree with Dean Johnson that what Congress has set out in the law needs to be complied with and followed by the president.
I think that's where I would agree with John. It's, Congress passes the laws, the executive enforces the laws. We may have differences of opinion at various times about, what the law means that's passed by Congress, and we may have difference of opinion about whether the executive is enforcing the laws as passed by Congress. But I think all Americans, I believe, would agree that the proper role for making law is that, is in the hands of Congress and not in the hands of the president. And I do want to admit that the president has used some what I would call loose language in talking about changes in the laws, and I just don't see it that way. And I think that he misspoke.
Okay, that's all we have time for. We'd like to thank John Eastman of Chapman University and Kevin Johnson of the UC Davis School of Law for joining us to discuss the case. And thank you for watching Scholars Mate. I'm Donna Davis. We'll see you next time.